Good morning to everybody, and I must say I agree with Chiara that this was an excellent speech, and it's actually a very good introduction to our next panel. So this is a panel about the relationship between law and markets. And many economists consider frictionless markets as an ideal allocation mechanism, ensuring first best outcomes and thereby maximizing social welfare. In reality, such markets don't exist. Real-world markets are fraught with all types of imperfections, like market power or externalities. Financial markets in particular are plagued by frictions, most importantly, due to the pervasiveness of asymmetric information in financial relationships. A consistent set of legal rules is therefore indispensable to ensure the proper functioning and integrity of financial markets. For example, debt contracts and their enforcement crucially rely on a functioning legal and judicial system. And today we will have the pleasure to discuss the relationship between the law and markets with 4 distinguished panelists who cover a broad range of fields in both academia and policy. So let me introduce the panelists in their order of appearance. Katharina Pistor is the Edwin B. Parker Professor of Comparative Law and the Director of the Center on Global Legal Transformation at Columbia Law School. She specializes in comparative law, corporate governance, the governance of financial systems, as well as law and development. In addition to her numerous publications in leading legal and social science journals, Katharina has authored several books. The Code of Capital: How the Law Creates Wealth and Inequality has been praised by voices as diverse as Martin Wolf of the Financial Times and the economist Thomas Piketty. The Financial Times named the Code of Capital as one of the best books of 2019. Vivien Schmidt is the Jean Monnet Professor of European Integration and Professor of International Relations and Political Science at Boston University. Her areas of expertise lie in European political economy and political theory. Vivien's comparative work analyzes the role of Europe in a globalizing world, and her publications examine the impact of ideas and discourse on the dynamics of change. Published in 2020, her most recent book is Europe's Crisis of Legitimacy: Governing by Rules and Numbers in the Eurozone. Her book, Democracy in Europe, published in 2006, was named by the European Parliament in 2015 as one of the 100 books on Europe to remember. Marco Dani is Associate Professor of Comparative Public Law at the University of Trento. His areas of expertise comprise the constitutional implications of the European integration process and the question of how the judicial review of legislation can facilitate and impede government. He is known for his 2013 book, European Public Law from the Perspective of Conflicts, as well as many articles published in journals covering topics related to European and constitutional law. Finally, the discussion today in today's panel will benefit from the perspective of a policymaker. Barbara Balke is Director General and General Counsel at the European Investment Bank. Her successful career at the EIB spans over 2 decades. Before becoming General Counsel in 2020, Barbara was the Deputy General Counsel. Her earlier roles as Director of different legal departments at the EIB have provided her with expertise in corporate policy, matters related to the EIB statute, and legal aspects of financing operations in Central and Eastern Europe. Let me briefly introduce the discussion by identifying 3 broad themes, which are also taken up in the panelists' individual contributions. The first is the relationship between central banks and markets. The ECB is a player in financial markets, but it is different from other market participants due to its central role in providing liquidity and its power to shape markets through its monetary policy, as discussed by Katharina in her work on the legal theory of finance. The ECB's relationship with markets is delineated by our legal framework. We need to respect the limits of our mandate as stipulated in the treaties, with price stability as our primary objective and, without prejudice to price stability, the support of general economic policies in the Union as secondary objective. When pursuing these objectives, the ECB is subject to the general provisions of EU primary law in some specific rules, including the prohibition of monetary financing, as well as the principles of proportionality and of an open market economy. To ensure compliance with the legal framework, our monetary policy measures are subject to legal scrutiny by the Court of Justice of the European Union. The legal framework has direct implications for the implementation of our monetary policy operations, the front line of our interaction with financial markets. It imposes constraints on the terms and conditions under which we can intervene in markets. For example, it prohibits the buying of government bonds in the primary market. It prevents us from distorting markets through excessive bids, ensuring that we buy alongside the markets. And it guides us in choosing the monetary policy instruments with the most favorable balance of benefits and costs. This brings me to the second theme, the flexibility of legal frameworks, and this is closely related to what also the President elaborated on. While legal frameworks enhance legal certainty, they come at the cost of constraining flexibility. Legal rules ought to be sufficiently rigid to provide certainty to market participants, but they should also be flexible enough not to stifle adaptation to a changing economic and societal environment. From the perspective of the ECB, the treaties constitute a solid foundation for the effective implementation of our monetary policy. The legal framework has served us well in the past. Despite the clear limitations that the treaties imposed on the ECB, they provide sufficient flexibility to pursue our mandate in the face of changing economic circumstances. Our rapid and effective response to the pandemic illustrates this. Based on our existing monetary policy toolkit, we swiftly tailored our policy instruments to address the unprecedented economic shock. Our ability to design and implement forceful measures within our mandate was essential to mitigate the economic consequences of the pandemic crisis. In this regard, the ECB situation is similar to that of the EIB. As Barbara will argue, the flexibility of the overarching legal framework enables public institutions like the EIB to respond to long-term structural shifts in the economic environment. However, it can also lead to disagreements regarding its interpretation. In contrast, both Vivien and Marco see a need of greater flexibility of the legal framework of the Economic and Monetary Union, which they consider to be overly influenced by neoliberal thinking, with Marco advocating significant treaty changes. The final topic is political independence, which is one of the constituent features of modern central banks' legal frameworks. Historical experience has led to the view that the delegation of the task of maintaining price stability to an independent institution with a clear mandate is best suited to solve the underlying time and consistency problem of monetary policy. Since the late 1970s, legally protected independence has allowed central banks to effectively safeguard price stability, resulting in a long period of low and stable inflation. However, independence is only granted in exchange for a narrow definition of central banks' mandates. In addition, the privilege of political independence necessarily requires public accountability. Thus, central banks' political independence does not discharge them from regularly reflecting on their role and societal responsibilities. In the context of the ECB's monetary policy strategy review, we therefore conducted public listening events in order to better understand people's expectations about the ECB's role and responsibilities. But this begs the question of the extent to which the ECB can respond to the public's request to address pressing societal issues, such as climate change or inequality, or whether this would lead to excessive politicization. One important legal constraint is that while the ECB must support the general economic policies in the Union, it is not allowed to autonomously make them. But this still leaves scope for the ECB to take such topics into consideration. For example, if they directly affect our primary objective or constitute side effects to be considered in our proportionality analysis. But is this enough? Katharina wonders whether central bank action can even be separated from autonomous policy making. Vivien asks how the ECB could gain legitimacy for choosing secondary objectives without requiring a change of the treaties. Marco goes a step further by openly questioning the ECB's primary mandate as well as the need for political independence. So, as you can see, this panel promises to discuss a broad range of fascinating topics, and I'm now very happy to give the floor first to Katharina. Thank you.
Good morning, everyone. I hope I can be heard over there in Frankfurt. I did prepare some slides. I can use them if you want to bring them in. I think the technique has them. Otherwise, I'm also happy just to start. So my topic really focuses on the interaction of monetary policy and private markets. And if you can just give me the next slide, please. So the basic argument that I will present here is that money systems, broadly defined, comprise both of public and private money. And by private money, I need credit or debt, which is produced in the private sector through lending. So lending is the source of private money creation based on private law and shielded by private autonomy. So we don't only have a central bank that is shielded by independence from the political process, we also have private markets that are shielded from political process through principles of private autonomy and private law adaptation, if not creation. So it's not only that the ECB faces questions about actually who makes the law, who interprets the law, who has the final say, but private actors also can make law, can interpret the law. They do this in everyday transactions, of course. And then the question is, how many of these transactions are ever being looked over by a court? Relatively few, I would say. So lending is risky. And stability requires that lenders or debtors have at some point access to liquidity, which only some states and their central banks can provide in the last instance. Some liquidity can come from private actors, but only to a point. Money systems, as defined above, public and private money systems, thrive in the space between private autonomy and central bank independence, and with only partial and incomplete regulation and supervision by public interest. Next slide, please. So what I want to just briefly discuss here is the legal theory of finance that Isabel Schnabel already mentioned. This is a theory I developed about a decade ago based on a close reading of the financial crisis of 2008. And the basic building blocks are very intuitive. Financial systems are also creatures of the law. Not only the monetary system of the European Union is creature of the law, but financial systems are. They're based around contract, property rights, credit, collateral rules, trusts, corporate law. We all use these institutions to create financial assets and to create financial intermediaries. This means that financial markets are essentially hybridic. They're never just private or just state, they just interact. A critical component of the legal theory of finance is what I call the law and finance paradox. So we need law to scale markets, to be able to interact with one another in anonymous markets where we can't monitor our participants and know them, but where we have to rely on the law. But if all legal contracts, including private contracts, are enforced as they were written ex ante, under changed circumstances, we're back to the topic of change that the president mentioned. If all legal commitments are enforced under changed circumstances, the system will crash. That's just what law does. It enforces all these rules at the same time, and then there won't be enough money to go around to make sure that everybody gets his due. Now, to get around that problem, we can make law relatively more elastic, and that could be just called an interpretation of the law or the suspension of rules, at least temporarily, and say we're now basically offering liquidity where no liquidity was due. We're doing bailouts or things like that, and that helps stabilize the financial system. Of course, it also compromises the law, but necessarily so. Next slide, please. So the two major parameters of money systems are private autonomy. Private parties may use the law to govern their own affairs without state intervention. They also are very creative in doing so. They recombine law, not only from a single legal system, but from multiple legal systems. And they can still invoke the coercive powers of the state. They can threaten with enforceability. Central bank independence, of course, the central banks, based on the independence mandate, conduct their monetary policies within the contours of their legal mandates. Again, they also can interpret themselves what this means, subject to judicial review, at least in the EU, not everywhere. They're not subject to direct state oversight. Next slide. So when you think about the creation of private money, you basically are looking at the different modules of the Code of Capital, as I call them in my book, contract law, property law, secured transaction law, trust, corporate law, and bankruptcy law. And we have created different types of private monies over the centuries: notes, bills of exchange, bank deposits, asset-backed securities, stable coins. This has been done through a process that I would call legal arbitrage. We have created deposits to replace notes. When notes were regulated, banks were no longer to issue them freely. We have created asset-backed securities when deposits were regulated because the banks were regulated. So legal arbitrage is very often something the private sector does to get around the constraints that the public sector imposes on private excesses. And we're basically therefore always sort of going through these rounds of regulating and then new innovation and then re-regulation. Next slide. So one more point before I get to the interaction of private money and public money. I think it's important also to realize that there are fundamental differences between public and private money. We typically talk about money as having three important features. It's a means of payment, it's a store of value, and it's a unit of account. Now, private money can be created as a means of payment. And of course, it's also a nice asset to hold because it usually gives higher returns than does public money. But it's has only limited power as a store of value because it can be highly volatile. The reason for that is that private actors, unlike public actors, have a binding survival constraint. And so the question whether these monies will survive is one that is on the minds of other market participants. In contrast, states, at least states that are monetarily sovereign, or the European Central Bank, they can offer liquidity backstops without limits, really, because they're not subject to a binding survival constraint, and they use different types of liquidity backstops, but they have varied over time, and this is largely within their mandate. Next slide. This is just an example. We can skip this because of time, but I just want to show how the European Union has, the ECB has changed its collateral framework over time. So you can see that there are legal adaptations made in part in response also to what's happening in the markets and how markets innovate the kind of assets that they're trading and that are seeking liquidity in the last instance from the European Central Bank, in particular in times of crisis. Next slide. So what I want to come here to is what Perry Mehrling has once called the quixotic dance between central banks and private markets. So it's not just that there are natural markets out there that function and then central banks intervene or governments intervene, but private markets are creating assets and intermediaries in anticipation of what this might give them at the central bank, for example. Central banks, in turn, depending on the theory about markets that they have, they might think that they want to naturalize everything they're doing. They want to anticipate what financial markets might do and the next move they might be making. But this also then implies that market actors and the central banks are watching each other and trying to anticipate the next move. In the end, they probably have to dance to the same kind of music. And in the final end, of course, the central banks have to adapt their liquidity and backstopping facilities to the moves that the financial markets have made, unless they want to allow them to crash and self-destroy, which they're likely to do under the law and finance paradox that I mentioned earlier. Next slide. So let me move to a really important issue, I think, that we want to consider here, and that has been also part of recent debates around the European Central Bank and other central banks in the US as well, of course, is the question of what actually is the impact on both central bank policy and also of financial markets on inequality. I have made the argument that private law helps to create wealth and inequality, and I think you can also see this in financial markets, which are coded in law, of course. So just focusing on the European Central Bank or other central bank policies during the last couple of years, including the COVID crisis, clearly asset purchase programs support asset holders. There are relatively few strings attached when these programs are made, and the intermediaries such as banks very often have hoarded liquidity rather than pass it on, and there's relatively little that central banks can do through their instruments here. Another question, of course, is whether this really impacts what is called among economists structural inequality, whether not other factors such as whether workers have sufficient rights, whether they can unionize, maybe technological change or educational attainment are more responsible for inequality. I want to argue that finance, the private law aspects of financing, the relationship between monetary policy and financial market development also have a role to play. Next slide, please. So when we think about structural inequality, I think we can think about three important aspects that impact inequality. One is financialization. That means the attempt to solve many social problems through financial means, for example, to allow people to have access to credit in lieu of social provisioning. Best example in the United States, of course, is the program to securitize mortgages, which was launched in the late 1960s to give people access to housing, which they otherwise would not have. Globalization is another aspect, and globalization is not just something that happens outside states or outside state law, but it's basically a means by which we make domestic law portable and allow people to bring foreign law to our shores and conduct private transactions with them. That, of course, curtails government power because I might have a lot of financial assets or intermediaries operating on my shore over which I do not have control, at least not with regards to private law, maybe through regulation. And of course, it also increases private leverage over politics because there's always the threat that we might leave again. So regulatory competition plays a role in the interaction between financial intermediaries and financial markets and governments as well. And last but not least, I think when we look at the debt overhang, that's a problem not only for governments, it's a problem for households and private firms. And of course, it also has something to do with how we structure our financial markets. So we have a lot of resources that are needed now to pay back debt, and that will constrain future activities. And of course, adds to inequality because not everybody is equally able to deal with their debt. Next slide, please. So let me conclude here. The basic argument that I'm making is that lending liquidity in the law is a story about how social resources, one, the law, it's a social resource. The other is public money, also a social resource, are used for private wealth creation. The distribution that results from this private wealth creation is highly uneven and is increasingly becoming more uneven because much of the activities are done by trying to fashion new assets from law and invest in these assets because this is very often easier to make money in this fashion than to invest in the real economy. The centrality of money for the economy self-enforces the need for liquidity support. So it's not just what central banks do, but it's also what markets do and how they structure their assets. Structured finance, of course, is a product of the law and of the attempt to create sort of new assets using legal means. And ultimately, this limits the space and capacity of politics for other purposes. It limits both what central banks can do because it binds them to the mast of trying to save financial markets from their own follies. It also limits the space for governments. And so looking at these interaction between financial markets, private markets, so-called, but using law and public enforcement devices, central bank independence and public power left to government, I think is something that we have to consider more in the future. So thank you very much for listening. And I'm looking forward to hearing my fellow panelists.
Thank you so much, Katharina. That was a clearly very fascinating presentation. And I hope we're going to come back to this very interesting question of the relationship between money, central banking, and structural inequality. So I think that is really thought-provoking, and I hope we can come back to that. So let me now hand over to Vivien for her introductory remarks.
Yes, so delighted to be here, wherever here is for everyone other than Frankfurt. I have a slide show, so I hope that will be put up. But in any case, I'll start. My talk is on the power of ideas in capitalist transformations and the democratic backlash. And my main point is that the markets are not only shaped by the law, they're also reshaped by the law. And my argument is that a particular understanding of the role of the law, or in my terms, the state, and its relationship to the markets, i.e. capitalism, has remade both the state and capitalism since the 1980s. And here I'm, of course, talking about neoliberalism. So that's the title, and now we should just go on to the first slide, please. And that's just a brief outline of my talk, where I'm going to be talking about neoliberal ideas and their impact. I'll begin by defining neoliberalism, discussing then the resilience of neoliberal ideas over time, i.e. the law, and then examining the impact of these neoliberal ideas on capitalism, markets, then how this in turn has led to a democratic backlash and the rise of populism. And then I follow with the COVID-19 response and ask what next. And there I'll look more closely at ECB macroeconomic policy, Commission industrial strategy, and the question of how do we decentralize and democratize EU economic governance for a better future at all. So, you can think about this talk as thinking about the ideational environment in which the European Central Bank operates. So next slide, please. So defining neoliberalism, and here obviously this is going to be very short, but it's a philosophy of the political economy with a core set of ideas about markets and the law. Here, when I use the law, I mean the state's role. And it's a view about that markets should be as free as possible and the state should play a limited political economic role. There are obviously two neoliberalisms, the one of Friedrich von Hayek and Milton Friedman. We found it most prominently in the US and the UK. And then there's ordoliberalism, neoliberalism with rules. That's Walter Eucken and the Freiburg School. And here there's a more active rules-based sense of the state with greater social obligations. But importantly, neoliberalism is not simply a philosophy of political economy, it's a philosophy of political democracy, which conceives of the polity as the individual first, the community second, with legitimate state action to be very limited regarding community-based demands on the individual. Next slide, please. And what's important to see, and this I think takes us back to President Lagarde's discussion of the important role of reinterpretation. And this really is about the reinterpretation through neoliberal ideas of what capitalism is, what the roles of the market, what the role of the market, what the markets do. So here we start with a conservative neoliberal rollback of the state to free the markets from the 1980s to the early 1990s. Thatcher in the UK with a very ideological discourse quoting Hayek on the spirit of enterprise, the importance of individual responsibility. Reagan in the US, the great communicator with a neoliberal discourse on supply side economics and the dangers of the state. And of course, this approach to capitalism spreads everywhere. You see it even in France as Mitterrand moves from the neo-Keynesian relance to the great U-turn, which he argued in macroeconomic policy, which he sees as necessary for modernization. He doesn't use the neoliberalism in his discourse. And of course, by the early 1990s in Central and Eastern Europe, you get radical shock therapy of the economy, and this is Balcerowicz in Poland. Next slide, please. But that's the 1980s. By the 1990s, the conservative project is stalled, and in its place comes the social democratic neoliberal rollout of the state to enhance the markets. This is in the US, Clinton and the New Democrats using neoliberal processes to reach social democratic goals. In the UK, it's Blair, New Labour, a very pragmatic approach to the third way. And here he really rescues Thatcher's revolution, if you will, by applying it to the welfare state. But instead of a discourse of the Thatcher's discourse of the worthy poor versus the feckless and the idle, he talks about welfare as not a hammock, but a trampoline, not a handout, but a hand up. Love that phraseology. Anyway, at the same time in France, Jospin's socialists, you get a more pragmatic approach, the middle path, the ni-ni, neither soak the rich nor let them go without paying their due. And Schroeder in Germany, again, a pragmatist who is persistent in the face of plummeting popularity, allowing time for neoliberal reform coordinated between the social partners and government. So we go from conservatives to social democrats. And next slide, please. And then end up with a supranational ramp up of the state to globalize and Europeanize markets in the 1990s. This is the Washington Consensus, the WTO, the OECD, and the IMF promoting such neoliberal ideas. And even in the financial crisis, so my favorite quote is Greenspan at the Fed, who lets the bubble go on until it bursts with tremendously disastrous effects. In congressional hearings, when asked about his neoliberal ideology, he admits that, quote, those of us who have looked to the self-interest of lending institutions to protect shareholders' equity, myself included, are in a state of shocked disbelief. Yes, but what happens is sort of the neoliberal sort of set of ideas become resilient in any case. After 9 months of neo-Keynesianism with bailouts of the banks, neoliberalism comes back. And we see it in particular, not just neoliberalism, but ordoliberalism in the Eurozone crisis. And this is very early on, this is 2009, even before the Greek crisis starts, that Jean-Claude Trichet at the ECB, Schäuble as German finance minister, call for a return to ordoliberal ideas about stability. Then when the Greek crisis really hits, the Eurozone crisis starts, you've got Merkel's ordoliberal stability discourse against Sarkozy's Keynesian solidarity, and the ordoliberals win. And this means that the crisis is framed as one of public profligacy, reading off Greece, rather than private excess, which is all other countries. The causes are then diagnosed as behavioral, member states not following the rules, rather than structural, linked to the Euro's design. And this leads to no real solutions. Instead, we get governing by rules and ruling by numbers, in the subtitle of my book on Europe's crisis of legitimacy. But importantly, after two years, we do see an important change. The ECB promises to do whatever it takes to save the euro and then moves on to QE. The Commission reinterprets the rules ever more flexibly, and the Council also reinterprets the rules. It goes from a focus on stability alone in 2010 to growth and stability by 2012, to flexibility within the stability rules by 2014, and investment in 2015. Things get better, but the suboptimal rules remain, and legitimacy is also at risk. Next slide, please. So what I've been doing is talking about the ideas, but it's important to see what impact they've had on capitalism itself. And here, for globalization, we see that neoliberal ideas transform national capitalisms. As states liberalized the financial markets, deregulated business, weakened labor, marketized public services, rationalized welfare states, reduced taxes, as well as capital mobility grew while manufacturing moved offshore, labor markets dualized, and workers' wages stagnated. Next slide. Then, of course, it's not just globalization, it's also Europeanization. And here, and I should say, these are all great innovations, but at the same time, it's important to see what changes they wrought in capitalism. The single market and the single currency reduced the state's room for maneuver. State aid, of course, is a tremendous limitation, as well as the Stability and Growth Pact on debts and deficits. So both macroeconomic policy and microeconomic view. And then, of course, there was the Eurozone crisis. when the Stability and Growth Pact is reinforced. In the first 2 years, austerity becomes the watchword for all. There's an emphasis on low debts and debt. And what this means over time is those without the fiscal space could not invest, and those with the fiscal space did not invest, which helps explain why we find ourselves today in a serious problem of lack of investment with crumbling infrastructures, etc. But on top of this, the structural reforms, especially for countries under conditionality, meant that they crushed labor unions and cut the welfare state, putting them in a much more difficult position with the pandemic. But next slide, please. It's important to look, those are general statements. It's also important to look in more clearly at the impact on different varieties of capitalism from the post-war. And here, the post-war liberal capitalism of what we could call liberal market economies became more radically neoliberal. The post-war managed capitalism of coordinated market economies liberalized more slowly, and they maintained their basic profiles, even though what you saw is significant shifts in terms of pensions and the welfare state. But importantly, and in particular for coordinated market economies, they were advantaged by the macroeconomic policy within the kind of ordo-liberal assumptions of the Stability and Growth Pact and macroeconomic policy more generally. Next slide. Here, importantly, we need to look at what happened to sort of state-influenced market economies. And these basically reversed course. The state has become a pale shadow of its former self. The state is less able to enhance the markets, especially France, while still able to hinder them. We can hear talk of Italy and Greece. The one-size-fits-all export-oriented growth model imposed special burdens on countries with different growth models. And it's important to see that the coordinated market economies, as I mentioned earlier, flourished, largely because export-oriented growth requires organized labor markets and other institutions able to repress wages and hold down domestic demand. This is much more difficult for liberal market economies and state-influenced market economies. They have less organized labor markets and are more reliant on demand-led growth. This is particularly problematic for state-influenced market economies with weak export sectors. Although it's also true that those with strong export sectors lost market share. So this is really France and Italy compared to Germany. But equally important, we lose the importance of the state's traditional role, which can no longer serve as an engine for growth, which it essentially did in the post-war years, and which is also unable to invest either in growth-enhancing areas or in the social safety net. Needless to say, this hit especially hard Southern Europe for countries under conditionalities, as we then saw in the pandemic. Next slide. So what are the implications of this? Well, these neoliberal transformations have had a major impact on citizens concerned and really fueled the democratic backlash. This is about the socioeconomics of people feeling left behind, the losers of globalization, the rise of inequality, as we've just heard. It's about the 1%, as Piketty talked about, increases in poverty. But this also then morphs into sociocultural fears of those worried about a loss of status, about the changing faces of the nation. This feeds into anti-immigration and nativist resentments. And then, of course, but it's not just socioeconomic and sociocultural, it's also about the politics of those who want to take back control. Mainstream parties actually end up being hollowed out as we see the rise in the extremes on the right in particular, but also on the left. And of course, there's also pushback against technocratic depoliticization. And this really comes in for the EU. Next slide. And so what does this lead to? This is the democratic backlash against neoliberal transformations. This is the milieu, the economic, social, and political milieu in which populist messengers circulate their anti-elite, anti-liberal messages via the medium of social media and traditional media to get votes, seats in parliament, and governing power. Next slide. There is, we could say, some kind of light at the end of this tunnel, because although at a moment of great crisis, because the COVID-19 response leads us to ask if there's an end to neoliberal resilience. Have we learned the lessons from the Eurozone crisis? Certainly, the responses to the crisis have really changed and in important ways. You know, if you think about the suspension of the Stability and Growth Pact rules and numbers, the massive national bailouts, the ECB's pandemic purchasing program, the EU's creation of an unprecedented European Recovery Fund, etc. So next slide, what's next? And here what I wanted to do now is go from this more general discussion of the neoliberal ideas that have been behind all of these changes, that in the end, one could argue that however necessary or salutary at early moments, now have gone too far. So there are many ideas about what the ECB could do, and you've been at the ECB discussing these quite effectively. It seems to me there's a move from a focus on primary objectives to considering secondary objectives. What about making full employment a target on a par with fighting inflation? No neutral bond buying, green bonds for the environment. But importantly, with all of these discussions, the main question is how one democratize this discussion. How do you ensure the accountability of the ECB as it moves forward? Yes, it's independent, but it's also in the shadow of politics. So how do you do this? How do we legitimate? One way would be to increase ECB accountability to the European Parliament, perhaps with more and more robust ECB European Parliament dialogues. Another way, which I've been thinking about for a while, would be to create new venues for democratic debate and deliberation on EU macroeconomic governance. Think about a great macroeconomic dialogue, for example, a yearly conference to give ECB direction for its secondary objectives. It remains independent, but it's not simply listening, but it's also engaging with a wide range of EU institutional actors and the public, civil society groups, etc. Next slide. So we also need to, of course, consider Commission industrial policy. The EU has had a great leap forward through the Next Generation EU and the Resilience and Recovery Fund, but that's only temporary. There's still need for a permanent fund and more budget. And one also needs to think about permanently suspending or at least reforming the Eurozone debt and deficit rules, coming in perhaps with a golden rule for public investment in growth enhancing areas. Eliminate the debt brake from national constitutional legislation. Certainly the lesson of the past decade is that one cannot cut one's way out of public debt through austerity. The only way out of debt is through growth. But for all of this, one needs to decentralize and democratize the European semester. This is again about responding to the populist challenge. The semester already is much more bottom-up than top-down, as in the past. And it's the member states deciding how to promote growth via the NRRPs, the National Resilience and Recovery Plans. But one needs to decentralize the process to regions and cities and to democratize it by bringing in social partners and civil society actors at the national, regional, and local levels, but also to ensure that national parliaments are part of the national processes. And of course, that the European Parliament is involved at the EU level in the European semester. After all, the RRF has a redistributive function. One needs the kind of accountability that comes with the European Parliament involvement. And finally, here too, why not think about industrial policy dialogues, bringing in all the stakeholders? It could conceivably even be brought in with the macroeconomic dialogues. And here in conclusion, next slide, please. And I won't go on into the many possible obstacles and stumbling blocks, because that could be another presentation. But of course, political divisions remain in the European Council, especially the Frugal 4+. There are dangers if the RRF fails to deliver on growth. And if the rule of law is not enforced for Central and Eastern European countries, it's also the case that neoliberal austerity hawks are likely to be back. And there's a real danger if the Stability and Growth Pact rules are not changed or at least relaxed. And here, there are many challenges also, not only from the populist backlash, but the fact that we are in an existential crisis with regard to climate change. In short, Eurozone governance requires an ECB which benefits from political guidance via great macroeconomic dialogue, a commission with a permanent fund, with flexible rules of oversight for differentiated evaluations of member states' economies, for general, perhaps, targets established through industrial strategy dialogues, and greater bottom-up decentralization and democratization. All of this could help combat the deteriorating politics in which citizens have been voting for populists out of frustration for their lack of voice and choice. Thank you.
So thank you so much, Vivien, for this interesting presentation. After listening to you, one wonders what actually is still the role of markets in your opinion relative to the state. So what is the role of markets for innovation, actually also for the green transition, for digitalization and so on. And I think maybe we can discuss that later, but I also think, we've been talking a bit about inequality. Of course, we have to acknowledge that while inequality has gone up within countries, we've actually also seen that that global inequality has decreased, so that quite a few countries have come out of poverty, and markets may have played a role in that. So let's discuss that later. But first, let's listen to Marco, please.
Good morning. Let me start by congratulating the organizers for this event and thank you for the invitation, which was unexpected and flattering. In this presentation, I'm going to sum up the contents of a paper prepared for this conference, whose title is Openness, Purposiveness, and Alignment of the EU and the Democratic and Social Constitutional State. Next slide, please. It is a paper that tries to answer to the following question: can the economic rules enshrined in the EU treaties coexist with a democratic and social constitutional state? My answer to this question is negative. Namely, I claim that the EU, and notably the Economic and Monetary Union, is misaligned with a democratic and social constitutional state. Indeed, after an excursus which departs probably from most conventional accounts for the European integration process, I argue that the EU has evolved in a prevailingly purposive constitutional order, whereas the democratic and social constitutional state remains a prevailingly open constitutional framework. Finding that in many respects this state of things is problematic, in the last part of the paper, I put forward a set of proposals to realign the EU and the democratic and social constitutional state. Following early suggestions by Dieter Grimm and Fritz Scharpf, the paper concludes by claiming that a realignment of those two institutional frameworks requires first and foremost the drastic deconstitutionalization of the Economic and Monetary Union. Next slide, please. Let me first of all clarify that the theoretical framework underlies my argument, namely the notions of openness and purposiveness. In the paper, I contrast two ideal types of constitutional orders. On the one hand, the purposive constitution, which includes detailed substantive norms embodying a particular political and economic religious doctrine, assumed as an uncontested truth. This type of constitutional order is characterized by a high transformative aspiration, and within it, legislation is conceived of as essentially in terms of implementation of a predefined regulatory project. On the other hand, we have the open constitution, a document establishing open-textured substantive norms, . embodying a compromise among political forces of fundamentally differing views. Compared with purposive constitutions, open constitutions display a lower transformative capacity, but they are much more inclusive and adaptable. Now, in the paper, I note that in the real world, constitution makers are not faced with a blunt choice between openness and purposiveness. In designing actual constitutional settings, they tend to combine purposive and open elements in an attempt to strike a difficult balance between transformation and inclusiveness. Indeed, in those efforts, they have to come to terms with the inverse correlation existing between those two claims. The starker the purpose of a constitutional order, the weaker its inclusive and adaptive potential. The wider the semantic scope of its norms, the looser its transformative capacity. On this theoretical basis, the paper identifies an age of openness, starting from the end of World War II to the Maastricht Treaty, in which both national constitutional orders in the form of the democratic and social constitutional state and the European economic communities tend to cope with that trade-off by privileging openness over purposiveness. The democratic and social constitutional state relies on a prevailingly open constitutional framework as a way to institutionalize the social question and the conflicts existing between the political forces involved in the new constitutional beginning. Accordingly, the pursuit of the bold transformative goals enshrined in national constitutional documents is not superimposed on society, but is viewed as an essentially political undertaking, attainable primarily through democratic competition and legislative deliberation. In other words, the purposes of the democratic and social constitutional state are exposed to and not shielded from political conflict. Emblematical of this approach is the commitment to activist government defined in the democratic and social constitutional state, which, depending on actual political preferences, is amenable to both Keynesian and ordoliberal legislative renderings. In my analysis, also the legal framework of the European economic communities up to the entry into force of the Treaty of Maastricht privileged openness over purposiveness. Designed to accommodate the tension between advocates of a multilateral framework enabling activist government and supporters of a laissez-faire international economic order, the founding treaties provide a set of market principles amenable to remarkably different readings. While for a long period of time, interpretative and regulatory solutions reconciling market integration and activist national policies are favored by European institutions, since the end of the 1970s, economic integration started to misalign with a democratic and social constitutional state by embracing a neoliberal orientation. Key developments in this regard are the move to mutual recognition in Cassis de Dijon and the Single European Act, the abolition of restrictions on capital movements, and the European monetary system. This new course of political economy gains foothold throughout the 1980s and consolidates in the institution of the Economic and Monetary Union by the Maastricht Treaty. Here, neoliberal principles and institutional arrangements are entrenched as a matter of constitutional law and as a reflection for all EU member states, the pursuit of alternative courses of political economy becomes exceedingly difficult. In brief, by reframing and sharpening in neoliberal terms the transformative aspiration of the treaties, the Treaty of Maastricht restricts the original openness, with considerable damage also for the inclusiveness and adaptability of national constitutional frameworks. Since then, however, the EU has held unflinchingly to this neoliberal agenda, and if possible, has strengthened its prevailingly purposive character throughout the economic and financial crisis starting in 2008. While the policy outcomes of this strategy are at least questionable, its constitutional shortcomings are evident. First, by committing in the treaties to a specific set of economic rules coherent with a particular political economy paradigm, the EU has encountered serious difficulties in using alternative policy tools when forced by unexpected economic and political circumstances. Those policies have been ultimately put in place by stretching the interpretation of key treaty norms, but the actual viability remains on precarious legal ground. Second, the same set of constitutional rules have de facto disenfranchised alternative courses of political economy, with the result of antagonizing the followers who increasingly regard the economic and monetary union, and as a reflection, the EU, as a toxic project to be overthrown. Next slide, please. Against this background, I would like to conclude by noting first that there is no meaningful added value in the described misalignment. Second, that realignment is possible by following two opposite ways. Either a top-down neoliberal realignment of the democratic and social constitutional state in the light of EU goals, or a bottom-up redress of the EU neoliberal bias in the light of the commitment of the democratic and social constitutional state, notably of its open character. If the latter option is favored, I am aware that this is a big if. The deconstitutionalization of the economic and monetary union arises out as one of the most pressing issues. In other words, the paper envisages a major treaty amendment in the direction of reopening EU policy-making to political competition. In this perspective, EU treaties, and in particular the legal framework of the economic and monetary union, should be pruned from all the policy prescriptions, leaving to political institutions and democratic competition the task of determining the purposes of its policies. But how would a deconstitutionalized and, as a reflection, prevailingly open structure of the economic and monetary union look like? Here are my proposals, fleshing out the idea of deconstitutionalization. They include, first, a partial redefinition of the goals inspiring EU monetary and economic policies. The goals currently included in Article 118, paragraph 3, TFEU, stable prices, sound public finances and monetary conditions, and a sustainable balance of payments will be confirmed, but full employment should be added to the list. Second, monetary policy would be defined as a sector-specific rather than purposive competence, without any constitutional prioritization of price stability or any other policy goal. But the goals and the scope of the ECB action would be decided by the Council and the European Parliament on the basis of the ordinary legislative procedure after consulting the ECB. Third, the no bailout clause and the prohibition of direct purchases of debt instruments should be replaced with legal basis enabling the Council and the European Parliament to specify the conditions for, respectively, debt mutualization and direct and indirect purchases of debt instruments. Fourth, the EU framework for economic policies should be based on a clearer distinction between shared constitutional principles, such as the prohibition of excessive government deficit and excessive trade imbalances, to be retained in the treaties, and more contingent fiscal targets to be defined by Council and the European Parliament with the ordinary legislative procedure. Fifth, the focal point of fiscal surveillance by EU institutions should remain narrow, limited to the size of government deficits and trade imbalances. Indeed, in a context in which national démoi are entrenched and salient policy choices on economic and social affairs are taken at state level, EU institutions seem ill-equipped to veto specific policy measures. In this respect, the Commission should be assigned a more general ex-ante suspensive veto on national budgets, with the possibility for the Council to override it with a qualified majority vote. Sixth and final, EU institutions seem also ill-equipped to impose specific measures on member states. To encourage the adoption of their preferred economic and social policies, they could only provide incentives in the form of conditional spending programs funded by the EU budget. I'm perfectly aware that despite the massive challenges posed by the pandemic, treaty reforms remain a taboo. But the meaning of these proposals is only marginally that of influencing ongoing debates on the shape of EU economic governance. What I think is most important at this stage is to offer a critical counterpoint, useful to clarify all the distance existing between current attempts that are being made to relax and humanize the EU neoliberal framework and an economic and monetary union really realigned with a democratic and social constitutional state. Thanks for your attention.
Thank you very much, Marco, for certainly very thought-provoking discussion and quite far-reaching proposals for how the treaties could be changed. I'm very much looking forward to the panelists' view on those proposals. So let us move on to the final presentation, which is by Barbara.
Good morning from Luxembourg, from grey Luxembourg, I have to say. We've had an announcement of the first snow for tonight, so we're looking forward to sort of the beginnings of a white Christmas season here. And happy Thanksgiving to my American co-panelists. Belated Thanksgiving. Thank you very much, Isabel and Chiara, for inviting me to this panel. And if Marco said that he was flattered to be invited, I probably was triple flattered, because to be amongst sort of such powerful intellectual thinkers for a practitioner like me is certainly a huge compliment and a huge challenge. So I was reflecting in the preparation of this panel what I could contribute from a practitioner's view. And I thought I would try to give you a couple of practical examples from my experience working in the European Investment Bank of this tension between the markets and the law, which of course we experience very much on a daily basis in our work. Or in fact, as President Lagarde has called it in her opening speech, the tension between the rule of law and the need of society to adapt. And that rang a lot of bells for me. And I found her speech really extremely inspiring and interesting. So what I'll try to do is just give you those examples from my practical experience and show a little bit how I see them in this topic of the tension between law and the markets. The European Investment Bank is probably, or I hope, is known to all of you, but just sort of as a couple of words of introduction, it is, if you want, one of the key financial instruments of the European Union, and was intentionally, when the treaties were signed in 1958, founded as a bank. So as a participant who refinances itself in the capital markets on the basis of its capital endowment, and therefore really acts very much as a market participant on the one hand, because in its refinancing activities, it is a market participant. On the other hand, of course, it has a strong policy objective in that it is supposed to finance projects in the interest of the European Union. And in that it probably is, if you could describe it like that, a microeconomic instrument, but with a macroeconomic purpose behind. So that is where you can already see this dual nature of EIB, which is not at all uncommon to other IFIs as well, because we all find ourselves in that situation. That of course means that you also find yourselves invariably at this crossroads between the law and the markets, because you have a political objective that comes to you via your shareholders, and at the same time you need to make sure that in the markets where you are acting, you are of course acting within the boundaries of law, but you are also in your refinancing activities. You are a strong market participant that can refinance itself at the rates and at the conditions that you need in order to fulfill your political purpose. So maybe I'll just start with a couple of examples that for me maybe epitomize this relationship. The first two are really examples of the dynamic interpretation that we have given to our legal framework at times in order to make interventions possible that maybe at first sight the strict boundaries of the treaty and of our statute as it stood at the time could have led you to say might go beyond those strict boundaries. And that's what I would just call dynamic interpretation. And I will also then afterwards show that with hindsight, these were always, if you want, reconstitutionalized, because at a later occasion, these changes that were perceived to be necessary for the bank to continue to fulfill its purpose were then at a later stage integrated into its statutory framework, and the situation was sort of brought in tune again. A first occasion of that kind was when you look at the original way the treaty was drafted and the statutes of the EIB were drafted, it referred to EIB financing projects always on the condition of having a guarantee from the member state where the project was located behind the financing, or having an appropriate, adequate other guarantee. So that could have been interpreted as always requiring that you needed a guarantee or security package behind. It became clear over time that that was very limiting, because you were actually excluding financing operations without security behind, but which in terms of the financial or the credit quality of the borrower that you were dealing with had absolutely the same quality and the same sort of financial and credit value to the bank as it would have had it had an appropriate security package behind. So at that juncture, and there I was really reminded by President Lagarde's intervention when she said, it's just so burdensome at times to adapt the treaty framework that you prefer to go with a dynamic interpretation. And that was exactly the case in that situation for EIB. So my predecessors in those days adopted a purposeful reading of the treaty and of the statute, and they said, well, you know, what this is supposed to ensure is that the bank only lends to first-class credit quality, and that can also be the case even if you don't have a guarantee behind. You can do that on what we call the single signature basis, so just on the basis of the strength of your borrower. That was in the Lisbon Treaty in 2009, finally also included in the statute, and it's now crystal clear that security is not a condition for financing by EIB. And this was one example. Another example in the 1990s was what was at the time called the Amsterdam Special Action Program. So this is when the Council came together and decided on a large action program in support of the European economy, and with an important focus on SME financing, which is, of course, one of the big areas of intervention of EIB and of our subsidiary, the European Investment Fund. And that Council conclusion also contained a call upon the EIB to step up its financing for SMEs, including financing in the form of venture capital, so equity financing. Equity financing in those days, in the 1990s, was not only not foreseen in the EIB statute, but there was actually an explicit, if you want, prohibition, because it said equity financing only in the context of restructurings where it's necessary to preserve the bank's position in the financing. So that was a bit of a predicament, because your own shareholders had called on you to do something that wasn't really foreseen in your statute. And the way that we got around it at the time was, again, to read the entire statute in a purposeful way, to say, here is a call from my own shareholders, my owners, to do something which isn't explicitly foreseen. So I got to find a way of doing it. And therefore, what we decided was that putting aside a part of the unallocated surplus of the bank. So the bank isn't supposed to make profits by treaty, but of course it does, as everybody does. There is a certain sort of surplus that you have at the end of the year. And in fact, a lot of that had accumulated over time, and there was quite a bit of unallocated surplus in the bank's accounts. And so what was decided at the time was, with a unanimous decision of the Board of Governors of the bank, following this call of the Council, you can take a part of that unallocated surplus and use this to do something that isn't strictly in line with and foreseen in our statute, but it actually fulfills an economic need at that point in time, and it fulfills a policy objective of the European Union. Again, that was later corrected in the Lisbon Treaty, and equity is now very much a statutory sort of part of our interventions. But it took us about 20 years to get there, or 10 years rather, 10 years to get to the reconstitutionalization of this instrument of equity. So these are just two examples of where we may have stretched the boundaries of the treaty and of the statute a little bit, but it was done in a way to stay in line with the political objective of the shareholders of the bank and of the Herren der Verträge, as President Lagarde called it. So in that respect, I would say it wasn't a development beyond the law. It was a rather sort of development within the scope of interpretation that you have. Then another maybe slightly different example of where we also see EIB on this crossroads of market and law is where, and that is a more recent example, where it has contributed to actually developing markets that were maybe not there before. And there I'm thinking in particular of the development of the green bond market, which the European Investment Bank was in fact the first one to issue a green bond in 2007. And that doesn't sound so spectacular anymore today because we're all very familiar with the whole regulatory framework that has developed around that. But in those days, that was not a product that was known in the financial markets. And yet it was felt that the policy purpose behind this and driving capital markets towards a stronger awareness of green policy objectives and actually putting the money where the policy objective is. That was something that EIB sort of took up, and where we went and made this sort of small contribution to the development of capital markets, and which was followed then by a whole set of regulation which didn't exist when we first started it, but which is much more solid today. So I thought that was also an interesting practical example of how these two sides can interact. And then my final example, and then I'll conclude, again, of balancing the legal framework, the statutory framework, and the role of EIB as a participant in the capital markets is what we call our Best Banking Practices project. And that is something that is relatively recent in EIB. And it's all about the question, how much banking regulation should we apply to an IFI or sort of a promotional bank and a multinational promotional bank like EIB. And as you know, the EU banking regulation is not directly applicable to promotional banks. It leaves that at the national level to the national legislators and regulators. And we, of course, not being subject to any national law, had to ask ourselves the question, so to what degree should it apply also to the EIB, even though the regulation as such does not apply. And there we have developed, again, sort of a dynamic concept of applying those rules that make sense for EIB, mutatis mutandis, if you want, picking those that have a sense to be applied to EIB as well, because EIB is a participant in the capital markets, and demonstrating that it has sort of a strong framework behind, where it constantly looks at its capital situation, at its liquidity situation, at its governance, all these elements that sort of form the pillars of the supervisory process for supervised banks. to some degree, they also make sense for EIB, and therefore, under this concept, we dynamically apply them to EIB as well. And again, this is something where we develop the legal framework in a way that is not written down anywhere, but that we feel makes sense because of our role as a market participant. So I guess in conclusion, what that all shows is that the European Investment Bank is in this constant dichotomy between the dynamics of the markets and the legal framework within which it acts. And on the one hand, and there I think I'm very much sort of, it resonates a lot what Katharina was saying. On the one hand, you need the strong legal framework because the legal framework provides an actor like EIB with an important element for its standing in the capital markets, because it's important for it to be a reliable partner for investors in the capital markets. So if the legal framework becomes too lax and you always go beyond and there are no sort of visible strictures anymore, then that really undermines your role as a participant in the capital markets. And then on the other hand, and there I have a certain sympathy also from our point of view, for the approach of Marco, to say, but your legal framework must not be so strict that you can no longer adapt yourself to the evolving realities and the evolving realities of your political mandate. And I think between those two positions, we as practitioners probably always try to sort of find our way in between. And sometimes we tend to go a little bit more to one side and sometimes we go a little bit more to the other. And that's where I leave it for the moment, and I look forward to the further discussion.
Thank you so much, Barbara, for adding this very interesting perspective from the practitioner side. So let's now move to the discussion. Unfortunately, we have very little time because we talked a bit longer than we had planned, but I think it was extremely inspiring. So thanks to all of you for making these interesting remarks. So maybe while I'm collecting questions from the audience, maybe some of you want to reflect a bit on the role that actually markets can and should still play in contributing to economic growth, innovation, and also social welfare. So, of course, several of you talked about the classical, like neoliberal thinking, where markets provide for an efficient allocation of resources, provide proper incentives, reduce moral hazard, and so on. But of course, we learned that you see this rather critically. So maybe you can elaborate a bit on that, but please be very brief. And in the meantime, I would ask our audience to raise their virtual hands. Thank you.
So I'm happy to comment briefly on this. So I think I have two responses to the questions. What can markets do, and don't markets also promote growth and actually erase maybe poverty, or at least reduce poverty? So I think, of course, it's true that opening markets and opening economic activities helps reduce poverty and gives people new opportunities. Two comments, though. One is that I think the greatest improvements have been made by countries such as China and India that did not follow a neoliberal Washington consensus approach to the letter. And the second point is that capitalism is actually not just a market economy, but a market economy on legal steroids. That is, we open markets and economic activities for many people, but some have better cards than others. And that's basically, if you have limited liability, if you have other legal protections, you will survive the next downturn that will invariably come much better than others. And I think we have to look at sort of the dynamics of economic development. We always see growth spurts and then differentiation within economies, and that has a lot to do with how the legal structures work in favor of some and in disfavor of others.
So if I could just jump in here, which there's of course a tremendous role for the markets, but what my intervention was all about is to remember that the state or the law has been shaping and reshaping the markets over time. And if we go back to neoliberal ideas, It's Friedman et al. Basically told actors that they had little or no social responsibility to communities, that corporations were responsible to the shareholders, that the pursuit of self-interest would lead to the public interest. But instead, what we found is that it's led to the rise of inequalities, that it's done nothing to address issues of climate change, et cetera. And what's important to see is that we are now seeing a shift in ideas about the role of the state, and for this, in terms of shaping the markets or reshaping the markets to take a better and a more proactive role in addressing the challenges of today. And I guess just to sort of finish this, what this means is, and this fits with what Marco was saying, if we consider what the resilience of neoliberalism has done, it's not just only about the fact that it's come back in different shapes and forms, but that it's also embedded in the institutions, and embedded in a way that it may end up constraining what we can do, so that it may be time to change those institutions. Maybe reinterpretation is not enough. And actually, what one could say is the kinds of reinterpretations that we've seen with the pandemic response has actually gone way beyond the treaties. And even the European Central Bank, if we consider what it did since 2010, or rather since 2012, it's been basically hiding in plain view the fact that it's massively reinterpreted the rules by reinterpreting its mandate to great effect. And we can see that in the fact that the ECB has been seen as legitimate in the way in which it's engaged in increasing monetary easing and expansionary monetary policy. Very interesting to contrast this with the Stability and Growth Pact, where we're seeing a backing off over time. From 2012, 2013 on, we've seen a reinterpretation of the rules where increasing flexibility has been seen as necessary, a recognition that some kind of investment is important, although really not until the pandemic, nothing significant. No great leap forward happened. So, which tells you that when we're dealing with legitimacy, in a way, the ECB has been legitimated, in some sense, by its reinterpretations, whereas the Council and the Commission, only once they started reinterpreting the rules seriously, and rolling back those rules, has there been sort of greater legitimacy. And I'll stop there.
Thank you very much. So let me give the floor to people from the audience. So the first question comes from Annelieke Moos, please.
Thank you so much for the opportunity to ask the question. It's an excellent panel, and I could ask 1,000 questions, but I will refrain to one, and that's addressed to Marco Dani. You spoke about adding the goals from Article 119 and 3 TEU to the ECB mandate. And I was just wondering, what kind of status would you award these goals? And how should the ECB deal with possible trade-offs between these different goals? Thank you.
I think it was directed to Marco.
So, yes, all those goals, I think, are well put in the treaty. There is only a telling gap, which is full employment, which is lacking among the set of the possible goals that should inspire economic and monetary policy. I think that it is not up to a treaty aligned with the democratic and social constitutional state to prioritize any of those goals. The very idea I have in mind is that the prioritization of those goals should not be left to the ECB, but should be politicized, which means that it should be up to political institutions to decide, depending on political and economic circumstances, which is the goal to be prioritized and what is the scope of ECB action. And the ECB should operate within a legislative mandate defined by political institutions.
Thank you very much, Marco. So I just learned that we can go a bit beyond the end of the planned end of this session because it's so interesting. I have so many speakers on my list. So the next question comes from Claudia Suarez, please.
Hello to everybody. My question relates to the question how to democratize the process in as far as the ECB is concerned. Can you hear me?
Yes.
Are you able to hear me?
Yes.
Okay, thank you. So is the answer by following the law, this is applying the current legal framework, not acceptable or sufficient, has been part of the answers that I heard today. But this has been used a lot regarding climate change. And I don't understand how is the treaty not enough, or the current legal framework not enough to allow the ECB to act. For example, the ECB is bound by the principle of an open market economy, favoring an efficient allocation of resources. To operationalize this principle, the ECB set the market neutrality principle. Can the ECB inform its understanding of the market neutrality principle with principles rooted in other areas of EU law, such as, for example, the polluter pays principle, precautionary principle, to fulfill its secondary mandate and correct the market? Is this not allowed and sufficient, acceptable? That's my question. Thank you very much.
Thank you very much for this interesting question. So I don't know who wants to respond to that one.
I think Marco would probably be a good person, but I'm happy just to throw in a little bit. So, this goes back to the question ultimately, who has the power to interpret the treaty? And I think primary actors such as the ECB, of course, is also interpreting its own mandate and its own action plan. And in theory, you could say it's enough, but you also need to have a kind of re-legitimization of what these institutions do over time. And so I think thinking about this feedback loop, how you do this through conversations, public conversations, through direct engagement with political actors, I think is the key question. But Marco, I think you're really the expert here.
Okay, my answer is the following, that of course you can stretch the mandate and deal also with climate change issues. But first of all, this cannot be done at the expenses, or that actions in this field cannot be detrimental to the primary goal, which is price stability. Price stability cannot be balanced vis-a-vis other competing rival goals, following, I think, an orthodox interpretation of the treaty. And second, if we move to a different type of interpretation of the treaty, there is, I think, an important accountability issue which emerges. Who is accountable for these kind of measures? Or who is accountable if the ECB doesn't do those measures? Are we only in a position to leave it to the discretionary evaluation of ad hoc agencies, these type of choices, or should we try to repoliticize these choices and to confer them, at least in the definition of the mandate, to political institutions? This is the gist of my argument.
So I would like to just jump in there to add to this. And so my idea of a great macroeconomic dialogue is actually to provide the kind of politicization that Marco suggested, but one that isn't limited to the council, where you get people focused on basically national interests, but have a dialogue amongst all the institutions, and arguably also bring in civil society actors, whether business interests or